This meeting of the Senate Judiciary Committee will come to order. It's my understanding that Senator Graham is on the way and has asked us to start. We'll, of course, recognize him when he arrives for any opening statement he may have. Last week, I went to the Senate floor and paid tribute to a fallen Chicago police officer, Andre Vasquez Lasso, 32 years old. He was an immigrant to this country, became a U.S. citizen, volunteered for the Chicago Police Department, and served there for 5 years. He was killed protecting the same Southwest Side neighborhood he lived in. On March 1st, Officer Vasquez Lasso responded to a 9/11 call about a domestic violence incident. When he arrived on the scene, the suspect fled and a chase ensued. The suspect had a gun, and when he ran into an elementary school playground with children present, he turned and fired it 5 times. Kids were taking cover under slides and equipment they could find on the playground. Officer Vasquez Lasso was killed. For his funeral last week at St. Rita's Chapel, his wife Milena wrote, and I quote, "I wish I would have hugged you stronger that Wednesday morning, given you more goodbye kisses. If only I had known it was the last time I would see you alive." Every day, millions of Americans, like Officer Vasquez Lasso, dedicate themselves to protecting public safety and keeping our communities and our kids safe. Law enforcement officers, emergency responders, social service workers, community leaders, and teachers. These are increasingly dangerous jobs, in part because there are more guns than people in this country, and hundreds of Americans are shot every day. We owe it to these Americans to enact laws that will help protect them from being shot and killed. I believe that well-regulated firearm ownership to keep America safe is consistent with the Second Amendment. But we're up against a gun lobby that wants to strike down the gun laws on the books and stop new ones from passing. And that brings us to the Bruen case. Here's a brief video.
For more than a century. But the ruling tonight impacts not only New York, but 7 other densely populated states with similar laws where 80 million Americans live.
Shocking. Absolutely shocking.
In addition, the court established a new test for determining whether gun legislation is constitutional.
The old test had history in it, but it also considered contemporary costs and benefits. What the new test apparently does is say no consideration of contemporary costs and benefits, only history.
What the Supreme Court said, what Justice Clarence Thomas said is, you can't balance the individual right against public safety, against protecting against violence and crime. You can only look at, quote, history and tradition. The NRA and other gun rights advocates are going to be able to go into court and challenge hundreds of gun laws that have been upheld by the courts.
A federal judge in Texas has ruled it's no longer constitutional to ban people under felony indictment for buying guns.
Appeals court ruled yesterday that the government can't stop people who have domestic violence restraining orders against them from owning guns.
So bottom line, a lot of gun laws on a lot of jurisdictions could now be vulnerable with this new standard that the Supreme Court has come up with.
For the record, the Bruen decision came down the day before the Dobbs decision, which of course drew a lot of public attention. The gun lobby got what it wanted in the 2008 Heller case, a Supreme Court decision making clear that the Second Amendment is an individual right. But the gun lobby wasn't happy with more than 1,500 cases that implemented Heller in the lower courts. Why? Because those cases largely upheld the gun laws on the books from constitutional challenge. The courts said those laws passed muster under Heller's then 2-step test that looked both at history and considered modern-day ends and means. That was just too much for the gun lobby to take. So they went to work. They advocated aggressively to put justices on the Supreme Court who supported a history-based approach to Second Amendment challenges, so-called originalism, literalism. I discussed this approach with both Justice Kavanaugh and Justice Barrett at their confirmation hearings because I was concerned about what a conservative majority on the Supreme Court would do to our gun laws. And then, as I feared, the gun lobby worked to get a case before the Supreme Court, the Bruen case. Last year, the court's majority went further than necessary to decide the case and established a new, purely historical test for considering the constitutionality of gun laws. The gun lobby was thrilled. Wayne LaPierre of the National Rifle Association put out a press release. He called the Bruen decision a landmark win for the NRA that, quote, unequivocally validates the position of the NRA. That's the same Wayne LaPierre who sat in this room 10 years ago and testified before this committee that we, quote, need to enforce the thousands of gun laws that are currently on the books. But his Bruen press release didn't say that. It said, quote, many unconstitutional gun control laws remain in America. The NRA will continue to fight these laws. Now, after the Bruen decision, long-standing gun laws on the books are being challenged across the country, more than 100 cases so far. And under the new Bruen historical test, judges decide not whether a law reasonably protects public safety, but whether the law resembles laws that were in place in 1791 or in 1868. In the beginning, in 1791, of course, we were talking about muzzle-loading muskets. I think about drawing that standard, legality and constitutionality based on 1791. And I think about last 4th of July in Highland Park, Illinois, when a deranged individual went on the roof of a downtown business and discharged 83 rounds in 60 seconds, killing 7 innocent people and injuring dozens of others, including paralyzing an 8-year-old little boy, Cooper Roberts. So it's no surprise to see decisions like the Fifth Circuit's recent Rahimi case. A panel of judges struck down a federal law barring those with domestic violence restraining orders from possessing guns. I can't square that decision with the actual danger that women and police officers face from armed domestic abusers. And I don't believe the founders of this nation would have wanted courts to simply ignore this danger when applying the Constitution they wrote. The chaos that the Bruen decision has caused was predictable. For 15 years, courts have been steadily applying the Heller decision to make reasoned judgments about gun laws on the books. Now, the Supreme Court has imposed a radical new framework under Judge Thomas's decision with barely any guidance to apply it, and plenty of opportunity for judges to cherry pick from history to engage in judicial activism in the name of originalism. The gun lobby saw Bruen as a landmark win, but it's a significant challenge for police, law enforcement, and the population of America when it comes to public safety. That's what we'll discuss today. We have a distinguished panel of witnesses that will examine where we go as we navigate Bruen's unprecedented upheaval of efforts to combat gun violence. I look forward to this discussion. I now turn to the ranking member, Senator Graham.
Thank you, Mr. Chairman. Well, number one, I think this is an important hearing to have. The role of the Second Amendment in average everyday life. Senator Cornyn worked in a bipartisan fashion to make some changes to background checks, putting money into the system to deal with folks that are a danger to themselves or others, to enhance public safety. So there's a bipartisan approach to some of these issues, but this sort of is the difference between the parties here, I would think. That America's Second Amendment was passed for a purpose. If you live in a kingdom and the king rules, the first thing they want to do is make sure nobody can object and that you're pretty well defenseless. You have to ask yourself, why did we have a Second Amendment to begin with? Well, if you understand the history of the country, people were fleeing England, where you couldn't say bad things about the king, you really couldn't express yourself. So the First Amendment allows you to speak openly and to worship the way you would choose, not the way the king would choose, and on and on and on, the right to assemble. The Second Amendment is to be able to bear arms. There are millions, 1.7 million times per year, people use firearms to defend themselves. I have a very long list of people who have been able to protect their family, their property, by having a firearm to ward off intruders and people who are acting aggressively toward them, particularly women. And Mr. Chairman, I'd like unanimous consent to put that in the record.
Without objection.
And what we're trying to do here, I think, is our Democratic friends are trying to make the argument that the Bruen Heller cases, if they could, they would overturn those decisions. And I think people on our side are going to be unanimous in the idea that responsible gun ownership is part of American society. Guns are used every day to defend Americans, and people abuse the right to own a weapon. And I would hope we could find common ground to go after those who abuse the right to own a weapon, who act irresponsibly and enforce the laws on the books. So what we will be doing in response to this hearing is that I've introduced legislation, federal law, that would basically codify the Heller decision that the Second Amendment right to own a weapon is an individual right, and the Bruen decision having a different legal analysis about efforts to regulate guns, more back to the historical perspective of why we have the Second Amendment. As you want to overturn these decisions, we will want to reinforce these decisions. We found bipartisan support for the idea of background checks and trying to get guns out of the hands of people who are dangerous, Mr. Chairman. But we haven't had much success in finding common ground on increasing punishments for those who are involved in crime. We're talking a lot about fentanyl, but we haven't done much to deter it. All of us see the laws regarding sexual exploitation of children in need of upgrading. So what I hope we'll find is some bipartisan support to go after the criminal and reinforce America's safety. This is a very dangerous time in America, Mr. Chairman. The policies being pursued in the major cities in this country are not working on the drug front, on the public safety front. And here's the sad news. There's probably never been a more important time to be able to own a weapon than now. The threats to the average American are going up, not down. And at the end of the day, the Second Amendment is part of our Constitution. It is part of the fabric of this nation. There is bipartisan support to make sure reasonable gun ownership reigns, but there will be, on our side of the aisle, Mr. Chairman, a robust response to the idea of undoing the legal framework that has come out of the Supreme Court, because we believe now is the time to reinforce responsible gun ownership, not to undermine it. Thank you.
Thank you, Senator Graham. Today we welcome 5 witnesses. Let me introduce them. Our first witness is Ruth M, President of Public Affairs National Coalition Against Domestic Violence. It's a project of the National Domestic Violence Hotline. Prior to joining this organization, Ms. Glenn had served at the Colorado Department of Human Services for 28 years, 9 of which she spent as a director of the domestic violence program. She is indeed a survivor of gun violence herself. Amy Swear has appeared before the committee before. She is a senior legal fellow in the Heritage Foundation, Edwin Meese Center, where her areas of scholarship include the Second Amendment, overcriminalization, school safety, and the intersection of mental health and gun violence. Eric Ruben, assistant professor at law at the SMU Dedman School of Law. His scholarship focuses on exploring the regulation of violence and weapons and how that regulation intersects with self-defense and Second Amendment. Rafael Mangual, did I pronounce that right? Good. Rafael Mangual is the Nick Ohnell Fellow and Head of Research for the Policing and Public Safety Initiative of the Manhattan Institute for Policy Research, where he writes on topics relating to police, crime, and incarceration, among others. And Stephen Lindley, who is the project manager for Combating Crime Guns Initiative at Brady. Before joining Brady, Mr. Lindley served in the National City Police Department in San Diego County and at the California Department of Justice. He has 27 years of law enforcement experience. I thank all of the witnesses for being here today. Each senator will have 5 minutes after you have 5 minutes for an opening statement. Could each of the witnesses please stand at this moment to be sworn in? If you'll raise your right hand, do you affirm the testimony you're about to give before this committee be the truth, the whole truth, and nothing but the truth? So help you God. Let the record reflect that the witnesses have answered in the affirmative, and we will recognize you in the seating arrangement that you've chosen. Ms. Glenn, you're first.
Good morning, Chair Dedman, Ranking Member Graham, and distinguished members of the Senate Judiciary Committee. I thank you for the opportunity to testify before you today on a critical issue, the impact of the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen on victims and survivors of domestic violence. As was stated, my name is Ruth Glenn. I am currently the Public Affairs President for the National Coalition Against Domestic Violence and the National Domestic Violence Hotline. I'm going to take my time to share with you why I do what I do, why it is important to speak to this issue, and how I hope to enable further understanding of the particular concerns for victims, survivors, advocates, and those that care for them when there is access to firearms by abusive, intimate partners. There was always a gun present during my 13 years of marriage. It was used as a tool to frighten me and control me. In one instance, when my son was 14 years old and he was struggling at school, my then husband aimed the gun at me, looked at our son, and said, "If you bring one more F in this house, I will kill your mother." I was so traumatized and terrified, I could hardly think. My experience was and is far from unusual. About 14% of women and almost 6% of men in the U.S. experience firearm threats from an abusive, intimate partner. 43% of those women who have been injured by a firearm include being shot, pistol whipped, or sexually assaulted. I wish I could share with you that that was the extent of my experience, but it was not. I am fortunate to be among that 43%. Fortunate because I was almost another statistic. One of the people murdered every 7 hours by an intimate partner, mostly with firearms. An abusive male partner's access to firearm increases the risk of intimate partner femicide 5-fold. A gunshot is the most awful sound. The smell is even worse, especially up close. I remember those two blasts, each one distinctly. The first went under my scalp, the other skipped off my forehead. When a bullet hits you, you feel a stinging sensation. Shock. Can't be happening. And then he shot me again in the arm. He drove away and left me for dead. This was pre-1994 when Congress passed the law prohibiting respondents to final protective orders from possessing firearms. I did not have the benefit of legal protections that are now afforded to survivors with protection orders almost every Supreme Court's rules the constitutionality of firearms law the historical judge panel of the Fifth Circuit Court of Appeals found it unconstitutional in the United States versus Rahimi. The legal implication as it applies only to Texas, Louisiana, and Mississippi, and it does not apply to state laws. And it does not apply to the relief written directly into protective orders. to realize the confusion and concern that has resulted from the ruling. It is also important to note that mentioning firearms in Texas, Louisiana, and Mississippi between February 2nd, when Rahimi was released, and March 9th, increased by 56.6% compared to the same time period last year. Given the general confusion, many respondents to final protective orders erroneously believe they are allowed to have firearms, and they believe they can no for protection from abusive partners with firearms. The lack of historical laws restricting firearms access by domestic abusers is not evidence that subordinate status and needs of women in early America. State laws restricting firearm possession by adjudicated abusive intimate partners to be upheld. However, in the interim, some abusive intimate partners will legally access firearms they were previously forbidden from possessing, and some will use those firearms to terrorize or even kill their victims and others. The uncertainty created by Bruen has placed victims and their children in fear of their lives and created yet another barrier to safety. Thank you again for the opportunity to testify today, and I look forward to answering your questions.
Thanks, Ms. Glenn. Ms. Swearer?
Chairman Durbin, Ranking Member Graham, and distinguished senators. Last June in Bruen, the Supreme Court affirmed that ordinary law-abiding Americans have a right to bear guns in public for self-defense. It struck down New York's restrictive public carry framework, which required applicants to prove they had a, quote, proper cause to exercise their constitutional rights outside the home, a burden that was usually insurmountable. Additionally, Bruen rejected lower courts' use of a heightened scrutiny approach, an approach that they, not Heller, created, and that in practice allowed many courts to never meet a gun law that they couldn't find perfectly constitutional. Instead, under Bruen, judges must assess whether the challenged restriction is consistent with the nation's historical tradition of firearms regulation. After Bruen, some pundits and politicians immediately responded with hysterical fear-mongering about its potentially devastating public safety consequences. Even today, the title of this hearing presupposes, albeit with fewer theatrics, that Bruen is a thing from which the public must be protected. This is simply not true. Bruen's immediate impact on public safety is positive. For too long, that their right to arms ended the moment they left force behind criminal gun. This is particularly true of concealed carry permit holders. At the same time, as I outline in much greater detail in my written submission, they play a significant but underappreciated role in crime prevention and crime interruption. Yes, good faith applications of Bruen will likely reserve generally laws that weren't very good at protecting the defective, at protecting the public. In recent months, as some post-Bruen challenges have succeeded in lower courts, the opinions and reasonings therein have been grossly mischaracterized in the same way we saw after Bruen. I cover this handful of successful and still largely ongoing challenges in more depth in my written submission, but the recent Fifth Circuit decision in U.S. v. Rahimi is worth highlighting. As others have noted, the panel struck down a federal statute prohibiting gun possession for individuals subjected to certain domestic violence civil restraining orders, and the opinion has been widely and wrongly denounced as meant from doing anything at all about it. The facts underlying that case. The defendant there, Mr. Rahimi, is a despicable cretin that no sane, sober, moral, or prudent person truly believes should own guns. Quite properly charged him with several crimes. But then apparently believing that a civil restraining order instead of pretrial detention was the best way of dealing with this violent individual. Predictably, Mr. Rahimi soon thought, to hell with your restraining order, and committed aggravated assault and order and its prohibition on his way to ignoring a lot of other gun laws. In a 2-month span, he shot at a guy he sold drugs to, he shot at a constable, he shot at the driver of a car crash he caused, fled the scene, returned in a different car and shot at him again, and then for good measure, fired a couple of rounds into the ceiling of a Whataburger restaurant. Let's assume, for the sake of argument, that the Fifth Circuit's interpretation of Bruen is correct, and the government can't charge Mr. Rahimi for violating his domestic violence restraining order because this is historically an inappropriate method by which to disarm people. Anyone who insists that this result somehow dramatically endangers the public either didn't read the case in good faith, does not understand the criminal justice system, or is very comfortable lying to your face. As the judges noted at length in that opinion, the Rahimi for pretrial either time that he violently assaulted someone. It could have disarmed him if and when Mr. Rahimi is ever released from prison. Every post-Bruen court agrees and him from owning guns killed. To any extent that Bruen limits the government's effective disposal to protect us from violent offenders. We are told all the time to respect the rights and needs of victims, as we should. We should respect them by detaining, arresting, and criminally prosecuting, defend themselves from these violent offenders when the government won't. I look forward to your questions.
Chairman Durbin, Ranking Member Graham, and members of the committee, thank you for inviting me to testify. My name is Eric Ruben. I'm a professor of law at SMU Dedman School of Law. Today I'm testifying in my personal capacity. This committee is considering how to protect public safety after the Supreme Court's decision in Bruen. So it is important to understand what that decision did and the challenges that it presents for the lower courts. I just heard one view on Bruen and its aftermath. I've read the opinions, and I'm going to provide a different view. I will make 4 points. First, Bruen abandoned a mode of reasoning used for almost every other right and inserted a new test for evaluating the constitutionality of modern laws addressing modern guns and modern problems. In particular, Bruen held that in cases where the Second Amendment's text applies, courts must assess whether or not a modern restriction is consistent with this country's history and tradition. And to do that, the Bruen majority said that the government has to point to analogous regulations from the late 1700s or perhaps the 1800s. Litigants in courts, the court said, are to compare how and why modern and historical gun laws burden armed self-defense. This is a novel approach. It's different than the one that courts were using before the Bruen decision came down, and in fact, it's different from how the court itself usually evaluates constitutional rights questions. Second point that I'd like to make is that Bruen has introduced a substantial amount of uncertainty for Second Amendment doctrine with this new test. The lower courts have struggled to apply Bruen to modern laws such as those regulating 3D printed guns, large capacity magazines, or gun possession by domestic abusers. Bruen purported to constrain judicial decision-making through a test of historical analogy, but the post-Bruen case law highlights the risk that, in fact, Bruen has enabled judicial subjectivity and unpredictability. In different cases dealing with the same laws, or even within the same case dealing with a law, courts have pointed in opposite directions about what the Second Amendment means. Third, as the issue of keeping guns out of the hands of domestic abusers show, courts are struggling with how to compare modern laws to historical ones in light of the immense changes between the past and the present. What meaningful historical comparator can they be for the modern prohibition on guns in airplane cabins or on automatic weapons? Perhaps more fundamentally, what about modern laws that reflect broader social change, like prohibitions on gun possession by domestic abusers? The domestic violence-focused gun laws highlight the challenge of basing today's constitutional decision-making on the legislative priorities of the distant past. The Fifth Circuit in the recent Rahimi case applied Bruen to strike down the prohibition on gun possession by people subject to domestic violence restraining orders. The court said that the record did not contain comparable gun laws from the framing era. But of course, there were not robust protections for the victims of domestic violence back in the framing era. Policymakers back then did not view women as the political or legal equals to men, and they did not prioritize protecting the victims of domestic violence through legislation. In fact, rather than focusing on protecting domestic violence victims, historically the law protected the husband's legal prerogative to inflict marital chastisement. But it would be absurd to think that the Constitution today condemns us to that same view. Fourth, and finally, despite the initial disruption that is caused, Bruen does not mean the end of reasonable gun policy. We have a long tradition of gun regulation in this country, and the justices in the Bruen majority said that properly interpreted, the Second Amendment still allows for a variety of gun regulation. The major challenge after Bruen is how to compare historical gun laws to modern ones in light of changed circumstances. The Rahimi Court, for example, recognized that historical laws disarmed various groups of people viewed to be dangerous, but it then construed those historical laws narrowly and concluded that they could not serve as analogs for the modern laws regulating gun possession by those subject to domestic violence restraining orders. But other courts have taken a different message from those same historical gun laws. In a case called Cantor v. Barr, then Judge Amy Coney Barrett looked at the same laws that were considered by the Rahimi Court. But she reached a different conclusion about their meaning. She wrote, quote, "History is consistent with common sense. It demonstrates that legislatures have the power to prohibit dangerous people from possessing guns," end quote. The central challenge for the Second Amendment today is ensuring that history and common sense do not part ways. Thank you for the opportunity to testify, and I look forward to your questions.
Thank you, Professor. Mr. Mangual.
Good morning, Chairman Durbin, Ranking Member Graham, and members of the committee. I'd like to begin by thanking you all for extending to me another invitation to testify before this body on what is perhaps the single most important policy issue of our time, public safety, especially gun violence. And my overarching point this morning is straightforward. When it comes to the important issue of public safety, our most pressing problem is not the possibility that more law-abiding citizens will now be able to carry firearms for self-defense in the small handful of states that didn't already allow them to do so prior to Bruen. It's that in so many parts of the country, legislative and administrative policy choices have exacerbated the risks associated with failing to arrest, prosecute, and meaningfully incapacitate high-risk, high-rate criminal offenders. As such, the focus of policymakers hoping to stem the tide of resurgent violent crime should be on identifying and plugging the holes created or made larger by recent depolicing and decarceration efforts. Failing to do so will inevitably lead to tragedy, as it has in so many cases already. One of those cases is the shooting death of Kiara Hudson Benefield in upstate New York last year. The 40-year-old mother was taking her kids to school when police and prosecutors allege she was fatally shot in the head by her husband. Her husband was released on his own recognizance the day before the shooting. That release came after being charged with savagely beating Kiara Hudson, an assault that was captured by a home security camera and shared with the authorities. And the release occurred despite the defendant having been paroled in 2015 after serving time for the armed kidnapping of an ex-girlfriend and escaping from a correctional facility. New York's bail laws required release and prohibited the judge from considering the danger that this man posed to his wife or the community. Perhaps the most tragic part of this story is that Kiara was so certain about the risk that she faced that she was reportedly wearing a bulletproof vest at the time she was killed. Instead of the safety that she needed, all the court would offer Hudson Benefield was a piece of paper containing an order of protection. Unfortunately, data from multiple sources suggest that when it comes to domestic violence, shootings, homicides, stories like the one I just told are all too common. A report published by the Indiana Criminal Justice Institute reported that the 3,036 individuals convicted of domestic violence in 2017 had a combined total of 15,396 prior arrests. A study done by the University of Chicago Crime Lab found that on average, those arrested for a shooting or homicide in that city in 2015 and 16 had 12 prior arrests. Nearly 1 in 5 had more than 20. This measure is in line with recent remarks from Washington, D.C. Metro Police Chief Robert Conti, who told members of the media earlier this month that, quote, the average homicide suspect has been arrested 11 times prior to them committing a homicide. What all of this tells us is that the laws that we have on the books regarding firearms restrictions, or any other criminal law for that matter, are no good to us unless we have the wherewithal to see to it that those who violate the rules are held to account in a way that actually protects public safety. And this is where the focus of policymakers should lie. We must be seeking to find and, where necessary, create opportunities to maximize the incapacitation benefits that attend the incarceration of bad actors. Actively supporting efforts to cut down on those incapacitation benefits is simply incongruous with calls for more gun rights restrictions as a means to pursue public safety gains. And yet cutting down on incapacitation is precisely what recent criminal justice reforms have achieved over the last decade plus. And these reforms, individually and collectively, have reduced the likelihood of arrest, prosecution, and/or incarceration for many criminal offenders, as evidenced by the 24% decline in the nation's prison population and 15% decline in the nation's jail population between 2010 and 2021, as well as a 25% decline in arrests between 2009 and 2019. None of that makes us safer, especially not those stuck living in the small slices of the country where crime concentrates. The downside risk associated with the push for decarceration and depolicing will be borne disproportionately by the very same people living in the pockets of concentrated gun violence. And this was made crystal clear by a study published last year and reported on by the Wall Street Journal, showing that the 2021 firearm homicide victimization rate approached 60 per 100,000 for black men, reaching its early 1990s peak, which is almost double what it was just 10 years ago. The white male rate stood in the single digits. America's gun violence problem has gotten significantly worse in recent years, and that should concern us all. The reversal of the progress made over the 1990s and early aughts has hit a very small slice of America in a very big way. Now, I'm encouraged by this committee's desire to engage with this problem, but I urge its members to consider that the policies most urgently in need of change are those that have lowered the transaction costs of committing crime or raised the transaction costs of enforcing the law. At the end of the day, rules without the means or will to enforce them are little more than empty threats. And for those stuck living in America's most dangerous neighborhoods, they're broken promises to boot. Thank you, and I look forward to your questions.
Thank you, Mr. Manuel. Mr. Lindley.
Chairman Durbin, Ranking Member Graham, and distinguished members of the committee, thank you for the opportunity to testify before you today. My name is Steve Lindley. I've spent my career in the service of public safety. For nearly 3 decades, it's been my honor to serve in law enforcement, starting as a cadet, working my way up to a detective, sergeant, and then a special agent. I made it to the upper ranks of the California Department of Justice and spent nearly a decade as the chief of the Bureau of Firearms. Today, I work with the Combating Crime Gun Initiative at Brady, one of the nation's oldest gun violence prevention organizations. I serve as a senior technical advisor on firearm issues, California gun laws, and the source of diversion of trafficked firearms. California was a very different place when I joined the police force in 1990. At the National City Police Department, we responded to shootings every night. Everyone in the streets had a gun, and by 1993, California had a firearm homicide rate that was 46% higher than the national average. Our streets were awash with guns and victims, and every day my colleagues and I put our badges and our vests on and hoped for the best. Almost every cop has a moment when gun violence really hits home. For me, it was in 1992 when I held a 16-year-old boy and watched the life drain from his eyes. He got into a fight over a girl, a fight that happens every day in our country, sometimes hundreds of times. Except during this fight, one of the kids had a gun. What should have ended with a bruised ego and maybe a black eye ended with that boy coughing up blood all over me. He asked if he was going to die, and I wish I could have told him he was going to be okay. I wish my story was unique, but it represents a bigger problem that requires more than thoughts and prayers. Between 1989 and 1991, California took its initial steps to address gun violence, passing an early assault weapons ban, comprehensive background checks, and prohibitions for violent offenders. Nationally, there was also a reckoning of gun violence, with Congress passing the Brady background check bill and assault weapons ban. California built in these laws, establishing a reasonable framework of gun laws, and it worked. In the last 3 decades, our firearm homicide rate was cut in half. Today, California remains the biggest state with many of the country's largest cities, but our gun death rate is 36% lower than the national average and 7th lowest in the country. It could have been much lower, but the most recent statistics from ATF shows that tens of thousands of guns traced to crime in California come from other states. Needless to say, we also share the national burden of mass shootings, most recently Monterey Park and Half Moon Bay. However, our laws, especially around assault weapons, make it much more harder for mass shooters to access the most deadly firearms. Californians are 25% less likely to die from a mass shooting than people in other states. We have some of the strongest gun laws in the country, and they're working. But rest assured, the Second Amendment is alive and well in California. We have more civilian-owned firearms than most other states. More than a quarter of Californians live in a gun-owning home, and Californians purchased almost 1 million firearms last year. This past summer, the Supreme Court upended California's long-standing framework with the opinion in Bruen. And today, California's assault weapons ban, high-capacity magazine ban, age restrictions, and ammunition background checks are all at risk. Federal laws are also at risk, including those passed by this body last year. In courts across the country, we're seeing confusion and activism in applying the new Bruen standards. States are being forced to reconsider every law as if it was written in 1791, when muzzle-loaded muskets and pistols were the only firearms available to the public. Evidence shows that laws protect public safety while representing Second Amendment rights. I'm neither a lawyer or a historian, but what I can tell you after nearly 30 years in law enforcement is that if gun safety laws continue to be struck down, it'll be harder for law enforcement to protect public safety and will make their jobs far more dangerous. After nearly 3 decades in law enforcement, I can also say that we cannot incarcerate our way out of this problem. We tried that, and it didn't work. While we all agree we need to enforce the law, we do not devote enough attention to the upstream source of guns being trafficked into our communities. Guns do not grow on trees, and they do not magically appear on our streets. In addition to my work at Brady, I'm also a high school teacher. My students worry about 1 million different things these days. Near the top of that list, are they going to be shot on the way to school or while at their desks? As I watch over my students, I'm constantly reminded of that 16-year-old kid who died in my arms, a kid who, today, could be in my class. He lost everything he was and everything he could have been. I look at my students and I wonder if I will lose one of them. Will one of them lose their future to senseless gun violence? Will my daughter? That's a question that terrifies me every day, a question millions of parents ask themselves every day. Thoughts and prayers are not enough. Action is needed. Thank you for the time today, and I look forward to your questions.
Thank you, Mr. Lindley. We'll start the questioning. I want to thank you personally, 27 years in law enforcement, and I want to thank all the men and women in law enforcement. We know that they are under close scrutiny and living lives which subject them to dangerous situations on a daily basis to protect us, our neighborhoods, and our homes. But let me ask you this point blank. We're in mourning in Chicago because 2 weeks ago today, an officer responded to a domestic violence incident, came across a man with a gun, chased that man who turned on him and killed him in a playground of a school in Chicago while the children around were cringing in fear. How often do domestic violence incidents, have you run into domestic violence incidents in your practice of law enforcement?
Thank you for the question. Law enforcement is one of the most difficult jobs I think we have in this nation. We ask a lot of our officers day in and day out. And one of the most unpredictable situations that they're called to deal with is domestic violence. They're going into a charged, emotionally charged situation, and not knowing what the basis of it is into a situation that may have taken years to come about. Also, you look at the different type of weapons inside the house. You have firearms, you have bats, you have knives, you have frying pans. It is a very difficult situation, and lots of injuries to law enforcement and injuries to the public come about from domestic violence situations.
So one of the witnesses here says, well, it's okay, Rahimi, if you accept it, that person would have a gun, they'll probably break some other law that they can be prosecuted. Does the presence of a firearm in a domestic violence dispute make it more dangerous for the police?
Absolutely. Firearms in the house when law enforcement's there in an emotionally charged situation, unless the situation is completely controlled, which is difficult for law enforcement to do these days, makes it very dangerous for them.
Professor Ruben, let's follow what the court has decided and see if you can help me understand it a little better. They've decided that they can't find, and Rahimi, they decided they couldn't find an analogy to removing a firearm from a person who was under a domestic violence protective order. And so as a consequence, they struck down the applicable law in that situation. And yet when it comes to the firearms themselves, they don't go back to 1791 and ask the obvious question. What did the founding fathers have in mind when they used the word arms? They seem to have expanded to almost anything. I used the example before in Highland Park at a 4th of July parade with a man on the roof of a building firing off 83 rounds in 60 seconds, killing 7 people, injuring dozens of others. There wasn't even a weapon imaginable in 1791 that could do that. How do they make that leap when it comes to arms to include that type of assault weapon?
Thank you, Senator. So this is one of the challenges and the questions that comes up after Bruen, is how can we make sense of our historical gun laws in light of the vast changes, including gun technology and also in terms of our moral sensibilities. We had blinkered moral sensibilities when it came to gendered violence back in 1791. And one of the points that I flesh out a bit in my written testimony is that if we're going to be approaching what counts as an arm at a high level of generality and allow that to evolve with the times, then we certainly need to find ways to likewise allow our regulatory frameworks to evolve as well to deal with modern problems today.
Ms. Glenn, you have a personal experience with this, which is chilling to think what you went through as a victim of domestic violence. What do you think about the argument that someone with a gun in a domestic violence episode is likely to break some other law that they can be prosecuted for, and that's good enough?
Thank you so much for the question. It certainly is not good enough. Without understanding the dynamics of domestic violence, and when there is a domestic violence situation in which an abuser has a firearm, and the escalation that occurs, and if you don't understand the dynamics of domestic violence, sometimes that's all that's present is the domestic violence situation. Waiting for prosecution or charging in that particular instance is unreasonable. Protective orders are built to help the victim provide themselves with protection. Removing the firearm is also that part of ensuring that safety and that they can be safe.
Thank you. Senator Graham?
Thank you. Ms. Swear, let's revisit, is it the Rahimi case? Is that the right name?
Yes, sir, I believe so.
Okay. Let's see what is the most compelling thing to learn from that case. How many times was this gentleman involved with shooting at people?
I'm not sure in total, but it seems like at least 6 or 7.
Okay, and he was released Based on what charge? He was facing a charge and released?
The first time he was facing at least one felony domestic violence charge and at 2 others. I'm not sure whether they were misdemeanors or felonies under Texas law.
Okay. Is it pretty fair to say that this guy should not have been out on the streets?
Absolutely not. He was very clearly a danger to both specific individuals and the public at large.
Mr. Mangual, is this a common problem where our criminal justice system has a revolving door when it comes to people who are exhibiting violent behavior?
It most certainly is a common problem, and one that is a long-standing problem as well. I mean, one of the statistics I didn't get a chance to get to was that between 1990 and 2002, the Bureau of Justice Statistics reported that over a third of individuals convicted of violent felonies were either out on probation, parole, or pretrial release at the time of those offenses. As our criminal justice system has gotten softer, that problem's only gotten bigger.
So when you look at what America is facing, would you agree with me the best thing we could do as a nation is to make sure that our parole laws and our attitude toward violent criminals is changed so that they are not out hurting people, they stay in jail?
I think that's exactly right. I mean, one of the biggest challenges that we currently face, as evidenced by the data on the role that repeat offenders play in serious gun violence, is that we are systematically failing to draw and enforce a line as to how much repeated criminal conduct we are willing to accept and tolerate.
Well, if your proposition is true, America would be responding in a certain way. Do you realize, Ms. Swear, that from 1991 to 2019, the number of guns in America number of weapons owned by Americans has doubled?
I am aware of that, yes, Senator.
Do you are aware of the fact the number of concealed carry permits have increased by 7-fold?
I know it has increased exponentially. I will take you at your word that it's roughly 7-fold.
Are you aware that between 2019 and 2020, 58% increase in gun purchases by African Americans, 43% increase by Asians, 46% increase in purchases by Latino Americans, 40% of those purchases are made by first-time gun buyers? Are you aware that from 2005 to 2020, a 77% increase in gun ownership by women, and that from 2019 to 2020, a majority of people buying guns were women? Are you aware of all that?
Yes, Senator, I am.
Why do you think that's going on?
It's because there are a lot of Americans, specifically, as you mentioned, women and ethnic minorities, who, a lot of them for the first time in their lives, beginning in the last couple of years, looked around at the state of reality in this country with sort of widespread and issues with policing, with...
Well, let's just stop there for a moment. Mr. Lindley, you've been a police officer. Thank you for your service. How's morale among police in America, generally speaking?
Thank you for the question, Senator. I think overall, morale is decreasing.
Yeah, and there are probably a lot of reasons for that, but it's harder to get people into law enforcement now, and I'd like to work with people to try to change that. Mr. Ruben, do you agree with the Heller decision that interpreted the Second Amendment to be an individual right? Was that a good legal decision?
Yes, sir.
You do? Yes. Yeah, thank you. Ms. Glenn, your experience was terrible. Your husband, former husband, had been charged with armed robbery. Had he been convicted of armed robbery, or I don't know, make sure I got
Yes, many years before the incident, yes.
Okay, and he had actually been charged with kidnapping you too,
Yes.
before the shooting.
Months before the incident.
Yeah, so I guess here's my point. Senator Cornyn has shown the way to work on responsible gun ownership limitations. I don't think there's anything in this case that says common sense doesn't prevail, but this Bruen case and Heller case are important in my view. Mr. Chairman, it reinforced the idea that the Second Amendment is there for individuals, and that individuals have a right to defend themselves in a responsible way, even outside their home. So what I would hope this committee could do is end, to the extent possible, the revolving door policies that allow people time and time again to come back out on the streets, hurt their fellow citizens. In this situation, I will just add in conclusion, the reason so many people are buying guns is because they've lost faith in their government to protect them.
Thank you, Senator Graham. Senator Whitehouse.
Thank you, Chairman. Thank you to the witnesses for being here. Professor Ruben, the history and tradition of fact-finding in the American judicial system is that it's done at the trial court level, and where the rare challenge, successful challenge to the very tough, clearly erroneous standard is made on appeal, then an ordinary way to resolve that is to send the case back to the district court for fact-finding, where fact-finding belongs. I've had a hearing in my court's subcommittee on this Supreme Court's recent penchant for appellate fact-finding. Some of the prominent cases have been Shelby County, where they made the finding that nobody had anything to worry about from the freed legislatures, that conditions had changed, and then, of course, immediately you saw a case come up in which federal judges said this is targeted with surgical precision at minority voters, completely discrediting the spontaneous fact-finding by the court. Citizens United was another one. They said that don't worry about it. All the unlimited spending we're going to unleash is going to be independent of candidates, and it's going to be transparent. And a couple of $1 billion of dark money, non-transparent funding later, we know perfectly well that that fact-finding was false. So this seems to be an increasing trend. And I noticed in the Bruen case, there was a lot of fact-finding done in the context of defining what the true history and tradition were. A lot of historians to look at that and said that is junk history, that is not real. It had not come up through any kind of an adversarial process. It was not tested in the different layers of review. It was just made up by the Supreme Court justices. Could you talk a little bit about the dangers of appellate fact-finding in terms of how it permits ambitious and activist courts to run a bit wild if they're not constrained any longer to facts as found through the traditional history and tradition of judicial fact-finding in lower courts and through adversarial process?
Thank you, Senator. So Bruen has transformed the way that litigation looks, transformed from before Bruen was decided when a more conventional approach applied. Now one of the things that we're seeing is that historians are getting retained by the parties. In fact, courts themselves are asking litigants whether or not they should retain their own independent historian to help them parse the historical facts. And one of the challenges that comes up, as you mentioned, is what happens on appeal, especially if a court on appeal is doing historical fact-finding that subsequently is determined to be erroneous. Are lower courts then bound by that erroneous historical determination when ordinarily there would be a route to appeal in challenges? So this is transforming the way that litigation is looking.
I think it needs to transform a good deal, because if you have an appellate decision that stands on what events have proven to be utterly false facts, and the appellate court hasn't gone back and cleaned up its clear error, then it becomes incumbent on the lower courts to take a look at that and see if it really makes sense, because Marbury v. Madison says that it's the job of the Supreme Court to decide what the law is. It has no particular expertise with respect to the facts. In fact, it's probably the worst part of government to make decisions about the facts, given the constraints on briefing and so forth. So thank you for that observation. The other thing that was notable about Bruen was that 12 NRA-funded amici showed up, and the funding disclosures at the Supreme Court have been a continuing source of frustration. The Judicial Conference is now looking at that, and I hope we'll be putting out a report fairly soon. But what is the danger if other parties and the public and the judges don't have a true and accurate description of who is really behind an amicus group that shows up in court, particularly as regards coordination of multiple amici?
Senator, I think that it's important to understand who is filing different briefs, just in terms of assessing whether or not there are any particular biases with the briefs that are getting filed.
Motive matters, right? Thanks, Chairman.
Thank you, Senator. Senator Grassley.
Thank you, Mr. Chairman, and thanks all the witnesses for being here to discuss this very important issue. I'm going to start with Mr. Mangual. Last year, I held a field hearing in Iowa for the drug caucus that I co-chair with Chairman Whitehouse. At that hearing, the Iowa Department of Public Safety Commissioner said that 42% of the murders that occurred in Des Moines in the last 2 years had a tie to drug trafficking. So I'm interested in your view on a national basis. How does drug trafficking factor in to increase that we've seen in violent crime?
Well, I think drug enforcement certainly can play an important role in the provision of public safety, and one of the main reasons for that is that there's a substantial overlap between people involved in the drug trade and people who are driving the serious kinds of gun violence that we're here to talk about today. One of the statistics that always comes to mind on this point is a statistic out of the city of Baltimore, which in 2018 reported that of the about 118 homicide suspects identified from the year 2017, 7 in 10 had at least one prior drug arrest in their criminal history. If you look at the recidivism data at the national level, the Bureau of Justice Statistics often reports on longitudinal analyses looking at the rate of recidivism for people who are incarcerated primarily for drug offenses. 75% of them will be rearrested for at least one non-drug offense, and more than a third will be rearrested for a serious violent offense specifically. And so if you talk to law enforcement agencies, I think what they'll tell you is that they view drug enforcement as a way to pretextually attack violent crime. Taking that tool off the table or minimizing it, as has been done through criminal justice policymaking over the years, I think can be significantly detrimental to our overall strategy to reducing gun violence.
Also, to what extent is the rise of violent crime connected with gangs or organized criminal activity?
Well, gangs significantly drive violent crime numbers, at least gun crime, in the sort of pockets of concentrated violence that I talked about in my testimony. If you look at places like the south and west side of Chicago, for example, the southwestern district of Baltimore, certain precincts in cities like Detroit and St. Louis, what you'll see is that gang members or crew members are significant drivers of the violence. That's true in my home city of New York as well. Identifying those individuals and singling them out for prosecution can be an effective strategy. There's one study done by an individual named Aaron Chalfin, who's a criminology professor at the University of Pennsylvania, on precision policing in New York City. And what that study found was that gang sweep prosecutions in New York City were responsible for a significant, I think almost 30% reduction in shootings over the time period of the study, which shows that if you are able to target your law enforcement resources at the small number of actors in the tight-knit social networks that drive gun violence, you can have an outsized impact on the safety picture.
Yeah. Last fall, the FBI released its 2021 crime statistics. Those statistics showed that the number of murders increased from 2020 to 21 by 4 3/10%. That's on top of the 29% increase 2019 to 2020. So to you, Mr. Mangual, that's a steep increase in violent crime, but isn't it true that the rates of violent crime have affected some communities more than others, and as an example, African-American community?
That's exactly right. I mean, the homicide victimization rate for African-American males is about 10 times that, the rate for their white male counterparts. And, you know, in my home city of New York, the New York City Police Department has been keeping data on gun violence and gun violence victimization since at least 2008 in a systematic way. And every single year for which we have data, a minimum of 95% of all shooting victims in that city are either Black or Latino. And I can assure you that Blacks and Latinos do not constitute anywhere close to 95% of New York City's population. And if just to really hit the point home on the geographic concentration point, which I think is really important to understand, in any given city in America, somewhere around 5% of street segments will see about 50% of all the violence. In my home city of New York, about 3.5% of street segments see 50% of all violent crime. About 40% of street segments don't see any violent crime whatsoever. I mean, just to really bring the point home with an example out of the city of Chicago, the 10 most dangerous neighborhoods in that city in 2019 had a collective homicide rate of 61 per 100,000. Collectively, the population of those neighborhoods was on average 95% Black and Hispanic. If you take the 28 safest communities in that city that same year, the homicide rate was less than 2 per 100,000. So this is a problem that disproportionately affects some communities more than others, and we should keep that in mind. And it should also be a source of comfort to know that we don't have to take a dragnet approach to enforcement to do the job well. We can target our approach because data tell us very clearly that a small number of individuals drive this problem.
Mr. Chairman, could I ask a very short question of Ms. Flair? Yeah. Can you tell us what the fastest growing group of gun owners in America is?
My understanding, Senator, is that that is specifically Black women.
Okay. Thank you, Mr. Chairman.
Let me add, since we're displaying our expertise on Chicago, that I know a little bit about that. And I would say poverty is an important overlay in this question. And it applies to Hispanic neighborhoods as well as Black neighborhoods. And I also think that if you're looking at the general population in the city of Chicago, you'll find that violent gun crime is now reaching beyond those areas into other neighborhoods because of social media and many other aspects. So there's a lot more to the story than what you just said. Senator Hirono?
Thank you, Mr. Chairman. In 2020, Hawaii had the lowest gun death rates and the third lowest rate of gun ownership in the entire country. Prior to Bruen, Hawaii police departments had only issued 4 licenses to carry in the past 2 decades. Following the court's decision, however, police departments across all counties in Hawaii have begun issuing licenses. As of December 2022, Hawaii County has issued 89 concealed gun licenses, and Maui County has issued 18. Between 50,000 to 60,000 people are expected to apply for a concealed carry permit in upcoming years. State and local officials have expressed concerns that lax gun laws may lead to a rise in violent crime. Consequently, county police departments have implemented stronger requirements for applicants seeking licenses to carry. State and local legislators have also introduced gun safety measures, including an enacted law in Hawaii County designating sensitive places, such as churches, where firearms are prohibited. However, gun owners have stated their intent to challenge these gun legislations in court. In September 2022, the National Association for Gun Rights, NAGR, filed a lawsuit against the state of Hawaii seeking to overturn the state's ban on assault pistols and large capacity magazines. The NAGR is seeking to challenge the constitutionality of these laws under the court's new framework in Bruen. The organization had filed 6 other lawsuits against state and cities with assault rifle or large capacity magazine bans. So a question for Mr. Lindley. Do you think that the concern over the thousands and thousands of applicants who will now apply for licenses in Hawaii and that this could lead to a rise in violent crime, is that a misplaced concern? Do you agree with the concern of law enforcement in Hawaii?
I do agree with those concerns, Senator. If you just looked at more guns equals safety, there's over 400 million firearms in the United States. If that was the case, we should be the safest country in the world. So more guns is not the answer to safety.
I agree with you. And the statistics I pointed to in Hawaii, where we have some of the strictest gun safety laws, and there is a cause and effect as to the use of guns in Hawaii in violent situations. Ms. Glenn, you have spent almost 30 years as an advocate for domestic violence victims and have testified today on the impact of Bruen on intimate partner violence. Just last month, the Fifth Circuit, in the first major case to apply Bruen, found that portion of the Violence Against Women Act that prohibited the possession of firearms by those subject to certain domestic violence restraining orders violated the Second Amendment. This kind of restriction was a common sense kind of restriction on violent abusers. How will interpretations of Bruen like this one in the Fifth Circuit make it harder to protect victims and survivors of domestic violence?
Thank you so much for the question. I think we go back to my written testimony, which is there has to be some type of protection that is allowed before the violence escalates. So having a protection order that says that I can have a firearm removed from the situation so that I am safer is very, very critical.
Well, I'd say under Bruen, maybe there's no historical basis for removal of a firearm in those kinds of circumstances. Professor Ruben, I really found it instructive that you said that this decision is transforming the way litigation is looking, and historians are being retained in cases. Justice Barrett in Bruen observed that the flaw of a historical approach to the Second Amendment and in the interpretation of the Constitution is that originalism is far from scientific. I would agree with that, and sadly, though, she went ahead and agreed with the majority opinion in that case. So I wanted to ask you, Professor Bruen, in the wake of Bruen, you examined New York's proposed legislation to require gun owners to have express permission from property owners to carry guns onto their private property, including homes, restaurants, offices, and entertainment venues. Do you think a law like that would withstand a Bruen challenge?
So, Senator, that law is currently the subject of litigation, some adverse decisions currently on appeal. There's a fundamental right to keep and bear arms, but it's important to recognize that there's also a fundamental right to private property. And there's nothing in the Constitution that says that the right to keep and bear arms has to trump the private property rights of other people. And so one of the things that law in New York does is it switches the default. Private property owners always have the ability to exclude people who are carrying gun if they don't want that person on there. All it does is switches the default about who has to ask who about the private property owner's preferences.
I applaud New York for their approach. And by the way, you know, before Heller, which was a 2008 decision, there was no explicit, in my view, right for individuals to own guns and also to own whatever the guns they wanted. Heller is a 2008 decision. How did we get along with the Second Amendment before then, I say? Thank you, Mr. Chairman.
Thanks, Senator Rono. Senator Cornyn?
Thank you, Mr. Chairman, and I appreciate a legal seminar as much as anybody. But what I'd like to see, whether we can get some agreement on some basic principles. First of all, Ms. Swearer, do you believe a law-abiding citizen is a threat to public safety because they exercise their Second Amendment rights to keep and bear arms?
Statistically, no, Senator. Law-abiding citizens are not a threat to public safety. They are overwhelmingly not responsible as a driving force behind criminal gun violence.
Well, one area that we're in this very, what can be a controversial topic, where I think we've been able to find some consensus is on the importance of background checks to make sure that people who are prohibited under existing law from purchasing or possessing firearms, namely people with criminal convictions, people with mental health commitments and the like. This has been one area where we have been able to find some consensus. A couple of years ago, we passed a bill called Fix NICS, which was after the Sutherland Springs shooting, where the Air Force had failed to upload criminal convictions of the shooter into the NICS background check system. Several of us went recently to Clarksburg, West Virginia, to see how the FBI is conducting the background check system, and it is pretty impressive.
More recently, as the chairman mentioned, or others mentioned, we were able to find some common ground on the Bipartisan Safer Communities Act. Again, in an area where it's hard to find much common ground. But I just want to update my colleagues on exactly what has happened so far with this, for example, the enhanced background check for gun purchasers between the age of 18 and 21. Unfortunately, it's a cohort of individuals who are disproportionately impacted by this profile, or disproportionately part of a profile that characterizes shooters from Adam Lanza at Sandy Hook to the shooter in Uvalde more recently. Using the enhanced background check authority that Congress passed in the Bipartisan Safer Communities Act, so far, the background check system has identified 101 potential transactions where juvenile records, which are now subject to the background check system, have disclosed individuals that have are either convicted felons, drug users, or those with mental health adjudications who otherwise, had they been an adult previous to that statute, would have already been prohibited from purchasing a firearm. At the same time, 98.5% of the National Instant Criminal Background Check transactions are unaffected by the Bipartisan Safer Communities Act. So it was focused on that cohort, that age cohort that was disproportionately represented in some of the mass shootings that we've seen around the country, and it seems to be working. Likewise, some of the additional penalties that we included for straw purchasing of firearms and trafficking in firearms has led to 30 indictments so far, just in the brief few months it's been in effect. Indictments of gang members, cartel members, and other violent criminals. Mr. Mangual, let me ask you, I thought you made a really important point about how what parts of the communities are affected by gun violence and others that are not as affected as dramatically, and how communities of color and where there's lower income levels are disproportionately affected. You're familiar, I'm sure, with Project Safe Neighborhoods, are you not?
No, I don't think I am.
Okay. Well, Project Safe Neighborhoods is a targeted effort, which you seem to allude to there, where you go after targeted enforcement of convicted felons and people who cannot legally possess firearms, and you prosecute those cases using the mandatory minimum standards under federal law to keep those individuals off the street. Is that a sort of targeted effort that you think might address this, what you identified in terms of where this is a big problem and where it's not as big or as urgent a problem?
I do. The kind of prohibited possessor laws that you're talking about that carry those significant sentences, I think, can be a really important tool in a targeted approach to addressing the gun violence problem.
Thank you.
Thank you, Senator Cornyn. Senator Welch.
Thank you, Mr. Chairman. I thank the witnesses. You know, this question of gun violence is really being affected by changes in analytic approach by the Supreme Court. The changes in the analytic approach by the Supreme Court, in my view, has resulted in a significant threat to the legislative prerogatives and a imbalance in the checks and balances that are so essential to the well-being of our democracy. The historical approach that the Supreme Court is taking to many, Senator Whitehouse, of course, is the leader of the subcommittee, has been a leader on this, is, in my mind, is creating the significant not potential, but the significant reality of the court essentially bootstrapping opinions to get to the result that it wants, and interfering in the legislative prerogatives and responsibilities that a legislature has to protect the well-being of its citizens. This historical approach I want to ask you about, Professor Ruben, you've been talking about it, but it is leading to some of these anomalies where things that the courts, lower courts are deciding in response to this seem to me to make no sense whatsoever. I'll just give a specific example. In the United States v. Price, a district court held that a federal law prohibiting possession of a firearm with an altered or obliterated or removed serial number, something that's essential in law enforcement investigation, was unconstitutional. And the reason was we didn't have serial numbers that weren't in common use in 1791. And the way I react to that is the court is the ultimate legislative body when it has the capacity to essentially waive away the rights of the people of this country through their elected representatives to address challenges that it faces as a society. Could you comment on that?
Sure, thank you. So you talked about legislative prerogatives, and indeed during this hearing I've heard a lot of comments about policies that in some people's opinions work or don't work. And traditionally, conventionally, that was what legislative bodies focused on. And one of the problems and concerns with the Bruen opinion is that the Bruen opinion said that, in fact, it's not modern legislative priorities that are most important for assessing the constitutionality of modern laws, addressing modern problems. It's the legislative priorities of legislative bodies over 200 years ago. Now, this still shouldn't cause all gun laws to be struck down. The court set forth some standards, but they're simply not specified enough to provide a lot of guidance. And so one of the things that we're seeing in the lower courts, including in the Price case and others, is that courts are emphasizing or de-emphasizing different historical facts. They're construing the history differently. And then they're reaching different results in the same case. So with respect to altered serial numbers, for instance, one of the things the Supreme Court said is that modern courts have to compare modern and historical laws in light of how and why modern laws impact armed self-defense. Well, it's unclear how a law that simply restricts somebody from removing a serial number has any impact on that person's ability to engage in armed self-defense. So there are differences of opinions there, and the opinions are coming out and pointing in different ways, different directions about what the Second Amendment means.
Let me just ask Mr. Lindley, all your work in law enforcement, how does it affect you? There's discussion about law-abiding people aren't the problem. We all agree with that. Makes sense. But you deal with a lot of other people who aren't so law-abiding, and also law-abiding people who have a temper and have a gun and have a domestic partner, sometimes in that moment are not so law-abiding. Can you comment?
So we've talked a lot about individuals and all the arrests that they've had. One of the things that we have here in the United States is you are innocent until proven guilty. You can have a lot of arrests. But individuals with mental health problems, convicted felons, people with a history of other types of violence, whether it's a misdemeanor, those individuals with firearms it's a poisonous cocktail, not only to the community, but to law enforcement, and they're very difficult and dangerous to deal with.
Thank you. Yeah, my time is up. Thank you. I yield back, Mr. Chairman.
Thank you, Senator Welch. Senator Lee.
Thank you, Mr. Chairman. I do think it's important in this conversation to remember that we're not talking about legislative priorities from 200 years ago. We're talking about a provision of the Constitution. It is different than a legislative priority. When we adopt something into the Constitution, we're making a law that's meant to stand the test of time. Unless or until that amendment is removed or altered, it stands, and it's the job of the court to interpret what that means. And that's exactly what happened here. I do think it is important, and I agree with Senator Welch that it's very important that we always focus on the rights of the law-abiding and keep those in mind whenever we consider legislation or legislative strategies here. One of the worst things you can do, particularly where a constitutional right is involved, but really in any case where you're dealing with something that involves public safety, is what are we doing that might make it more difficult for the law-abiding to defend and protect themselves? What is this legislation going to do to make us safer or less safe? It's important to remember a few dynamics that are well known with respect to this study of criminal offenses and with respect to advice that we've received from seasoned law enforcement officers. Just last week, D.C. Police Chief Robert Conti remarked that, quote, "If we really want to see homicides go down, keep bad guys with guns in jail." And he went on to say, right now, the average homicide suspect has been arrested 11 times prior to them committing a homicide. That's a problem. Mr. Mangual, do you want to respond to that? Is this, do you share this view that if we want to keep homicides down, we ought to arrest, convict, and detain those who are violent?
I do share that view, especially with respect to the last part of that, plan, the detainment part. I mean, the failure to incapacitate repeat offenders is at the core of America's gun violence problem and has been for a long time. If you look at the statistics on people who are charged with homicides or shootings, you will inevitably see long criminal histories that involve multiple arrests, multiple convictions, and often active criminal justice statuses. Until that changes, we are going to continue to deal with this problem, especially given the fact that over the last 10 years, we have exacerbated it by enacting all kinds of reform efforts that have, again, lowered the transaction costs of criminal offending in important ways, whether we're talking about bail reforms, discovery reforms, sentencing reforms, decriminalization efforts, the electoral success of the progressive prosecutor movement. All of these things have come together to make it less likely that when individuals come before a court of law after being charged with a gun crime or some other kind of serious offense, it becomes less likely that they will be prosecuted and incarcerated, and if prosecuted and incarcerated, less likely that they'll be there for a significant period of time.
And as a case in point, just recently, the District of Columbia Council voted to reduce criminal penalties for a lot of these same offenses, for the same bad guys committing violent crimes with guns. And so it defies reason and logic to say that that is not a problem when we know that is the source of the problem. It's also important for us to remember how the Bruen decision reached its conclusion and the constitutional reasoning on which it was based. I find especially helpful the penultimate paragraph in the majority opinion, which reads as follows, quote, "The constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. And is not how the First Amendment works when it comes to unpopular speech, or the free exercise clause, or protections with regard to the free exercise of religion. It's not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. And it's not how the Second Amendment works when it comes to public carry for self-defense." Ms. Swearer, do you agree with that assessment, both as a matter of constitutional reasoning and as a matter of logic when dealing with crime?
Senator, I absolutely do. The Second Amendment, especially in what we saw with New York's framework, was fundamentally treated and held to a different standard. You essentially had millions of residents who were told, regardless of what the text says, you might have a right to keep, but you don't have a right to bear arms the second you leave your home, which renders toothless that unalienable natural right to self-defense on which the Second Amendment is based. And so certainly for those residents in New York and the 7 other states with those types of public carry frameworks, their rights were being treated and held to a second-class standard.
I see my time has expired. As I wrap this up, I just want to emphasize again, the Second Amendment isn't something new. Yes, it is old. It's been in place since 1791. That's a long time ago. It doesn't make it irrelevant to our time. In fact, as we've seen crime increase, I don't think it's ever been more relevant, particularly when you look at those who were victimized, those who are at a competitive disadvantage with regard to size, strength, speed, wealth, assets, where they live in proximity to a police station, and the availability of police officers who could come either sooner or later to their home. This is, moreover, something that had its roots centuries before the American Revolution. These were well understood terms. This is not an exaggeration. This is not a modern day rewriting of a piece of the Constitution. This is a correct application and one that is right. Thank you, Mr. Chairman.
Thank you, Senator Lee. Next up is Senator Klobuchar.
Thank you very much, Mr. Chairman, and thank you. I had other hearings and things going on, but I caught up on your testimony, and I just want to thank you all for being here in this important hearing, and thank the chair for calling it. One of my focuses on guns has been on domestic violence. For too long, domestic abuse was considered a family affair, and they would say what happened in a house didn't have to come into the courthouse. We all know times have changed with the passage of the domestic violence bill, the reauthorization of it many times. But we also know that when a gun is present in the home, women in abusive situations are 5 times more likely to be killed, which is why, as part of the gun safety bill on a bipartisan basis, we put in a version of the bill that I have been working on with Senator Hirono and others for years to make sure that people that are convicted of domestic abuse can't go out and buy a gun the next day. As a survivor yourself, Ms. Glenn, can you first say more about the dangerous connection between domestic violence and gun violence? And then you could add on to that just your concern about the Bruen decision and what that will mean. Go ahead.
Thank you so much for the question. The concern, of course, is that what I stated earlier, which is that victims will feel less safe because there's the idea that at minimum, when and if I felt like I could do something about it, now I can't. I cannot get the gun removed. Secondly, I would say that we are also talking about abusive persons feeling a bit more freedom to take that few seconds to pull the trigger on a gun when there's domestic violence present by them. What we're seeing is widespread confusion, widespread concern about this particular ruling and what it will mean to the future. As we all know, domestic violence victims very seldom, if at all, call law enforcement simply because of the already present danger, particularly when there is a firearm in the home. The concern is really quite marked right now, what this will mean outside of that Fifth Circuit.
Okay, and I know, Mr. Lindley, you mentioned this in your testimony. Do you want to add anything?
Thank you for the question. With domestic violence and firearms, it's a lethal cocktail. You already stated the statistics that women are 5 times more likely to be killed when there's a firearm in the home with domestic violence. With that, there's also a danger towards law enforcement and just the greater community. So we need to really look at protecting those domestic violence restraining orders in order to ensure that women or other victims are protected, and we remove those firearms from an already volatile situation.
Okay, and I know you also are expert on this. So my state has passed a number of common sense gun safety laws to prevent convicted felons, fugitives from justice, and convicted stalkers and domestic abusers from getting a gun. And We also have this very strong tradition of hunting. It is a big part of our life with legal gun owners and people who are law-abiding, but yet we've been able to differentiate those that shouldn't have a gun, who have broken the law, and those that have not. And so could you talk about how the Bruen decision complicates efforts by state and local governments to protect public safety?
Thank you. So California has a program called the Armed Prohibited Person System, which identifies individuals who at one time legally purchased a firearm, but subsequent to that purchase became prohibited due to a mental health issue, due to a restraining order, or some type of act of violence. That has been a very successful program, identifying people who no longer have the ability to possess firearms because of an act that they've done or a mental health issue. It doesn't deal with individuals who are still law-abiding. So with those things combined, you look at Bruen, and again, I'm not an attorney, I'm looking at this from a law enforcement perspective, that could muddy the waters with who might be having their restraining orders removed because of some act going back to 1791. Things were far different in 1791 than they are today.
Okay, my very last question, Professor Ruben, in your dissent in the Bruen case, in his dissent, you didn't have a dissent, you probably were thinking one. In the dissent in the Bruen case, which was Justice Breyer was joined by Justices Kagan and Sotomayor, he asked this question. He asked, will the court's approach permit judges to reach the outcomes they prefer and then cloak those outcomes in the language of history? Based on the cases that have recently applied Bruen, how would you answer Justice Breyer's question?
History does not speak with one voice when it comes to the tradition of firearms regulation. And one of the big risks of Bruen that we are seeing right now in the way that lower courts are addressing constitutional questions after that opinion came down last June is that courts are picking and choosing different historical laws to emphasize. They're construing them differently. They're reading history at different levels of generality, and they're pointing in opposite directions about what the Constitution means. So without more clarification about how exactly to do the Bruen test, there is a real risk that opinions will, cloaked in history, will actually be subjective.
All right, well, I will ask the rest of my follow-up questions on many on the boyfriend loophole bills and laws, implications of these cases on that, but I will do that on the record because I know my colleagues are here ready to ask. So thank you.
Thanks, Senator Klobuchar. Senator Blackburn.
Thank you, Mr. Chairman. We appreciate so much that you all are here. It's an important conversation to have, and we are grateful for your testimony. You know, the chairman said he just couldn't square why some people would purchase guns or have guns. What I can't square is why we have prosecutors and judges who are letting criminals back out on the streets and not holding people who have committed crimes. And that's letting people that shouldn't have a gun get a gun. So let me ask, Mr. Lindley, let me start with you. Do you know who Jack Wilson is?
Actually, I do not.
Okay, you don't. Elijah Dickin?
I'm not really a name person, so no.
Okay. Well, let me tell you, these are both Good Samaritans that exercised their right to carry a firearm, and as a result were able to intervene during a mass shooting, one in Texas, one in Indiana, and they saved untold lives. These are the law-abiding citizens that we want to be carrying guns and whose right to do so is protected by the Second Amendment. What about Tyree Reynolds? You know that name? Christian Wingfield, do you know that name?
They're familiar to me, but not in detail.
Not in detail. Well, They should be. These are criminals who committed violent crimes using firearms, and then they were released back to their communities as a result of the radical left's soft on crime policies and the Soros-backed bail reform. So they got out. They went on to participate in shootings. One of these individuals left a child dead. So this is the disparity. It is outrageous, absolutely outrageous. Instead of prosecuting violent criminals who are committing these crimes, that many on the left are focused on criminalizing gun ownership for law-abiding citizens. Violent crime is raging across this country. We hear about it in communities. Every year I visit with each of our 95 counties in the state of Tennessee. I visit with law enforcement in those counties. And what we hear is with gangs proliferating, with drugs flooding this country because of the cartels, because of that open border, crime is on the rise. And there seems to be a penchant, though, from my colleagues across the aisle to restrict self-defense options. Senator Graham talked about this at the outset. This is a right. The Second Amendment is a right. Senator Lee just mentioned it's the only right, that you've got to go talk to a local official and get a license in order to exercise that right. But we have plenty of people that are alive today because Jack Wilson and Elijah Dicken chose to exercise that right, and in exercising that right, they saved a lot of lives during a time with a mass shooting event. And we ought not to have people that try to restrict self-defense options for Good Samaritans. They should be spending their time trying to get violent criminals off the street. Ms. Ware, I'd like to come to you for a moment. I led an amicus brief last month to support the lawsuit challenging ATF pistol brace rule. This imposes potential criminal liability on millions of Americans for exercising their Second Amendment rights. The ATF claims that this rule is necessary because arm braces transform a pistol into a short barrel rifle. Now, when I'm back at home in Tennessee and I'm talking with a lot of our veterans and our disabled combat veterans, they talk to me about why they rely on these pistol braces to be able to operate a firearm, to operate that gun. So can you explain how our disabled combat veterans use pistol braces and the devastating impact that the ATF rule would have on their ability to exercise their Second Amendment rights?
Senator, thank you for that question. Pistol braces work in such a way, so if you understand a handgun, which generally speaking, you can hold with one hand. A lot of these disabled veterans cannot use that second hand, for example, as a additional stabilizer, right? So they have trouble using that with one hand. The way that the pistol brace works is that it extends a lot of them down the arm and either allow the person with that brace to brace it against their inner arm or to even strap it into their forearm to give them additional stability.
So it's a safety mechanism.
Correct, yes.
It stabilizes the handgun.
Correct. And to the extent that someone is not disabled, they would have a plethora of other options. Again, whether this is a criminal, for example, they don't need to rely on a stable brace. They can just use a handgun or, for example, use a rifle. This exclusively is something that is beneficial to law-abiding but disabled citizens. And it might be used by people who are not disabled, but that is primarily a benefit to them, while at the same time, again, would-be criminals have a plethora of alternatives to accomplish their criminal goals.
Thank you, Mr. Chairman.
Thank you, Senator Blackburn. I want to thank Chair Durbin and Ranking Member Graham for holding this hearing. There's no denying that we have a gun violence epidemic in the United States of America. When gun violence becomes the leading cause of death in America, or yet another small town becomes a household name because across the country because of another tragedy, we have a moral obligation to act. Just yesterday, I joined President Biden in Monterey Park, California, to meet with the community that's still grieving from a mass shooting that took the lives of 11 people at a dance studio on the eve of Lunar New Year. I was pleased to see President Biden announce his executive actions that will make our community safer and will save lives. But I think we all acknowledge, including the President, that these executive actions to address gun violence do not absolve us of our duty as legislators. Now, last Congress, this committee held 11 hearings on common sense steps to reduce gun violence. And we know that the overwhelming public support these measures have. But as we gather here today, just after America surpassed 100 mass shootings in this calendar year, that's 100 tragedies by the first week of March. And Americans are watching from home, asking, when will Congress step up and do something? So I'm committed to finding a path forward and look forward to working with whoever is willing on the other side of the aisle to end the epidemic of gun violence in our country. Now, my first question is for Mr. Lindley. As a program manager for Brady's Combating Crime Guns Initiative and as a former law enforcement officer, you've spent a good part of your career combating gun violence. The Brady Handgun Violence Prevention Act created a system requiring background checks for gun purchases from licensed dealers. And yesterday, President Biden announced a new executive order directing the Attorney General to ensure that gun dealers are following existing laws concerning background checks, highlighting the role gun dealers have in limiting the proliferation of guns in our communities. Are you concerned that the Bruen decision will lead to looser gun laws, and in particular surrounding the registration of firearms, and then undermine our efforts to improve safety?
Thank you for the question, Senator. Absolutely. Again, I'm not an attorney, so I can't see the future when it comes to legal issues.
That's okay. I'm not one either.
Okay. But if you look at some of the things that have been put into place, especially with the Brady background check process, it didn't go far enough back in the 90s. So we do have to look at universal background checks, something that California has put into place and has been very successful with. You also look at limiting, if not, outline new purchases of assault weapons and high-capacity magazines. Again, something that California has put in and has been successful over the years.
Thank you. And I don't mean to make light of the fact that you're not an attorney, nor am I. Trust me, we hear from a lot of attorneys in this committee. There's a lot of attorneys on the committee. But I do want to uplift your perspective with your law enforcement experience to this conversation. Now, as a former law enforcement officer, you've experienced the epidemic of gun violence firsthand. And I think you'd agree that the Monterey Park shooting was simply a high-profile example of the epidemic that we have in this country. I mean, in a span of 8 days surrounding that one incident, California experienced at least 2 more. In your opinion, what role does the availability of large capacity ammunition magazines and semi-automatic assault weapons play in the gun violence plaguing our nation?
Again, after almost 30 years in law enforcement, seen far too many victims, far too many mass shootings. And when you look at the lethality of semi-automatic weapons, especially assault weapons, coupled with the high-capacity magazines, it makes it very difficult for the victimology. If you look at how many people can be shot in that time frame with a 30-round magazine as compared to a 10-round magazine. And we've seen instances here in California that an individual who went in, did a mass shooting, but had a lower capacity magazine, had far fewer victims. But individuals usually have to wait until the person reloads until they engage and try and disarm the individual. A lot of different victims can take place between 10 rounds and 30 rounds. Or, let's say in Las Vegas, 50 or 100 rounds.
Thank you very much. I'd love to have some follow-up questions here, but at this point, I'll turn it over to Senator Blumenthal for his questions.
Thanks very much, Senator Padilla. Thank you all for being here. Thank you to the advocates who have joined us today, and I want to thank Senator Padilla and other members of the committee for their steadfast support of measures that will stop that epidemic of gun violence. These measures are made vastly more difficult by the Supreme Court's decision in Bruen in ways that we have no way of knowing at this point, because Bruen remains an inchoate and deeply frightening potential obstacle to common sense measures. I could talk about a great many of them, but I want to focus on safe storage laws, known in Connecticut as Ethan's Law. Our law is named after a young man who was killed when he was accidentally shot by an unsecured firearm. Ethan Song was a teenager at the time, and the firearm had been stored in a Tupperware box in a closet alongside the ammunition and keys to the gun lock. Ethan's Law passed in Connecticut, but we know across the country 4.6 million minors live in households with at least one loaded and unlocked gun. An estimated 54% of gun owners don't lock all of their guns securely. Ethan's Law simply requires that guns be safely stored. Doesn't take away a single gun, doesn't look at who owns the gun, doesn't provide any ban on any type of gun. It simply says if you have a gun, you should safely store that gun. So I would like to ask Professor Ruben, based on the Bruen decision, whether that kind of law would be constitutional under the court's apparent reasoning that there has to be some historical analog on which any kind of law is based under the Second Amendment.
Thank you, Senator. So as you mentioned, there's a lot of uncertainty right now about what Bruen means and how it will apply to specific gun laws, including that one. Before Bruen, safe storage laws fared very well in the courts. And after Bruen, the question will be, first, whether or not the storage of a law or laws about storage fall within the plain text of the Second Amendment. That's an open question. And then the second question that will be asked is whether or not they have historical analogs. And it's a challenging one. It's a good example of the challenges that courts have now. Because back in the framing era, the guns were largely muzzle-loaded black powder guns that were not kept loaded or carried loaded because of the risk of misfire. There were laws about storage back then. For instance, there were laws in the city of Boston and other places about storing gunpowder separate from the firearms, but those were because there was a risk of fires. It was a different time with different problems, and the policymakers back then addressed the problems that existed. Today, the problems, as you mentioned, are different than the problems back then, and a lot will depend on how flexibly courts look to historical laws like the Boston safe storage law and how they relate them to today. And it's very much an open question. But one thing is for sure that the court did say that a lot of regulation is still permissible under the Bruen standard.
I think your point is very important, that an analog means exactly that it doesn't have to be exactly the same. And the laws, for example, that you cited in Boston requiring safe storage of some of the materials used in firearms or firing weapons perhaps provide that kind of analog. And today the risk may be different. In fact, gun deaths have recently surpassed any other kinds of deaths affecting children. Gun violence is the most common cause of child death in the United States today. An estimated 8 children and teens are killed unintentionally, injured, or killed due to an unsafely stored firearm. So the risk may be different, but the analog is the same insofar as it says risk can be taken into account in requiring safe storage.
And that's absolutely correct in terms of how courts are going to have to apply Bruen in light of changed circumstances. And one of the problems that I've seen in opinions that have come out after the Bruen decision is that courts, in effect, are looking for dead ringers. A lot of courts are sidestepping the analogical exercise altogether and just looking for dead ringers. Well, that's not how analogical reasoning works, and in fact, historical laws are going to have to be viewed at a relatively high level of generality, flexibly, in order to accommodate the reality of change over time.
Well, thank you very much. Thanks, Mr. Chairman, for having this hearing. I'm going to continue to advocate Ethan's Law at the federal level and other measures that I've introduced here, trying to encourage the courts to interpret Bruen expansively, because it really is a matter of life and death, and I commend President Biden for taking the action he did yesterday. Thanks.
Thanks, Senator Blumenthal. I want to apologize personally and for the committee. Our coming and going have a lot to do with things beyond our control. One of them is roll call vote on the floor. So members have to make the roll call and try to make this committee hearing, and others at the same time. It is not a display of disrespect. It's the reality of our frantic lives here when we're in session. But your testimony has been very important and very valuable. Professor Ruben, I was just trying to think, if we use the same standard of Bruen, of historical analog, we have a hearing coming up on social media and the internet, and I'm trying to imagine how we would do such a thing in light of the First Amendment, speech and press, and what we would be guided by. What really was the state of social media in 1791 or in 1868? I think it's ridiculous on its face. And you wonder why the court, particularly Justice Thomas, who has his own peculiar view of the Constitution, wonder why the court is buying it in this instance. Do you know what the end goal was, the real reason? Not the good reason, historical analog, but the real reason?
I don't know about the intentions of justices, obviously. One thing that happened before Bruen was that the courts were applying doctrine pulled from First Amendment cases. Heller cited First Amendment jurisprudence repeatedly. In the First Amendment context, we do not solely decide cases on the basis of history alone. Rather, history is one input, but so are contemporary costs and benefits. So to your point about social media or other First Amendment issues, the Supreme Court has said, for instance, that child pornography is not protected expression under the First Amendment. And in arriving at that decision, they were not looking for analogs in the founding generation. This is a unique test that has been put forward for the Second Amendment.
Senator Lee talked about the constitutional language standing the test of time. We might engage in an exchange as to whether or not the original language of the Constitution stood the test of time on the issue of women voting, on the issue of slavery, on the issue of property landowning males being primarily the voting populace at the time. There are a number of things in the Constitution which were flawed, some corrected by constitutional amendment and some by court ruling. Is that not the case?
That's true, and the Supreme Court in Bruen said that the Second Amendment is to withstand the test of time and change over time. And the question right now is how to do the Bruen analogical exercise in a way that will respect the reality of the fact that things were very different back in the 1790s than they are today. A lot of the problems that we have with respect to firearms and weapons today would have been unimaginable at the founding. So of course they weren't legislating on those issues. And yet our task, the task of courts and litigants today is to draw analogies between that time and now.
And I wonder how our founding fathers would have reflected on a chilling milestone as we surpassed 100 mass shootings a little over a week ago. That's more than one a day. We ended last year with 647 mass shootings, which means four people were shot or killed in an incident. 647 last year, almost 2 a day, and more than 44,000 people overall killed by gunfire. It appears the proliferation of weapons in America has not brought peace to our streets, but just the opposite. And that's what I've witnessed many times over. So I thank you all for being here today, and I thank you for your testimony. The hearing record will remain open for a week for statements and questions. I thank you for participating, and the hearing stands adjourned.